Down right now. We expect the closing arguments today and live in that Cheyanne Harris courtroom any minute. So joining me right now is trial attorney Abbas Kazerounian and, of course, criminal defense attorney Paige Pate is back with us. Abbas, I want to start with you. As we wait for the closing arguments, in your opinion, what do you have to do to make an effective closing argument from both the prosecution and the defense?
Well, first of all, good morning. Thanks for having me on. I think from a defense perspective, this is going to be a really uphill battle because it's going to be very, very difficult to try and keep the jury focused on the defenses, because at the end of the day, all the jury's been hearing are these heinous facts, and we had to have a dead baby, and the jury with these kind of facts is going to want blood. So I think it's going to be very, very difficult. And if I were the defense attorney in this particular case, what I would really, really want to be trying to do is focus the facts of your defense, which in this case is, you know, the drug abuse, the PTSD, and the depression. And I think one of the things that one of the defense attorneys said earlier in the trial is the real monster here is depression. But unfortunately, I just cannot see those facts overcoming the fact that you have a dead baby on your hands with such cruelty that's been described by the prosecution. And if I were on the prosecution side, I would just go over the facts over and over and over again. All the facts came out. You've got a baby that was allegedly, according to the experts of the prosecution, was sat there from 9 to 14 days without being fed, given anything to eat, and this like crazy infection from the diaper rash. I mean, those are very, very hard facts to overcome. Yeah, the details are horrific, and as Paige Pate explained earlier in the program, all the prosecution really needs to show is that she intended to neglect the child. Not that she intended to have the child die, just that she intended to neglect. That's a huge point to make, and we're going to talk about it in a second. Right now, we're live in the Cheyanne Harris case. Jury instructions are currently underway, so let's listen in on it right now.
Full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt, and you should find the defendant not guilty. 11. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. 12. Prior sworn testimony from Zachary Cohn was read into the record. This testimony was taken under oath before the trial and preserved in writing. Consider that testimony as if it had been given live in court. 13. In this case, the defendant did not testify. The defendant is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of the defendant. 14. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act, and he did it voluntarily, not by mistake or accident. You may, but are not required to conclude a person intends the natural results of his acts. 15. Serious injury is a condition which cripples, incapacitates, weakens, or destroys a person's normal mental functions, or a bodily injury which creates a substantial risk of death. 16. Bodily injury means physical pain, illness, or any impairment of a physical condition. 17. The marshalling instruction. Under count 1, the state must prove all of the following elements of murder in the first degree.
Okay, so Paige, I want to come back to you as we listen to these jury instructions. One of the things that we had talked about was this general intent and specific intent, And with general intent, as you said, all they really need to prove, the state, is that she intended or knew what she was doing in terms of the neglect. So how does the defense argue against that and saying, maybe there was neglect, but she didn't intend to neglect him. But again, he was there for such a long time. So how do they show that she didn't intend to neglect the baby?
Well, Jesse, I'm interested to hear that, because it's hard to think how the defense can present an explanation of how this happened without admitting that their client committed this crime, or at least neglected the child. What I do expect the defense to do, if there's any evidence to support it, is try to focus on something else. I mean, you can't focus on the child and all the graphic details of how he was found. You can't, I don't think, focus on Ms. Harris and her substance abuse or depression. I don't really think that helps them in this case because the jury's not going to sympathize with her. So what else do you have? I think you have to go back and focus on the father. He was already convicted of this. He was guilty, no question about it. He was in the home. What could he have done differently that may have changed and may have changed the life of this baby? You've got to find something, but it's going to be very difficult for the defense to overcome the evidence in this case.
And Paige, I'm so happy you mentioned the father because his testimony from his trial was read through a transcript yesterday in court. We're going to talk more about that. Let's take a quick break, and when we come back, we'll either be live in the courtroom or we'll have a lot to talk about. Stay tuned. Okay, so as we listen to the jury instructions, let's get some perspective before the closing arguments. Abbas, one of the things that the jury heard yesterday, they didn't see the testimony of Zachary Cohen because he chose not to testify, pled the fifth, but really the more interesting thing is his testimony from his trial, that transcript was read to them. What impact does that have on them?
I think it has a massive impact because I mean, the fact that the jury is going to know of this other trial, and I know that the defense actually changed venue on this case, which I thought was was interesting. But the fact that the jury's aware of it, they know what happened in his trial, I think is devastating for the defendant in this case. I would have done everything to keep it out, but I don't think you can keep it out. Like it's devastating for the defendant.
Paige, is there any way to throw the blame on the father? I mean, the idea here that he was found guilty, he was a negligent party, she was suffering. Is there any way that they could have argued that?
Well, I think you can share the blame, if not completely throw the blame on him. You can at least suggest to the jury that either one of them could have done more, and then take advantage of what we were just listening to. We heard the judge go through the jury instructions, laying out not just the more serious crimes that she's charged with, but also these lesser included offenses. In other words, an opportunity for the jury to say, yes, what you did was wrong. We're going to find you guilty of some crime, but maybe not the most serious. And that's a great strategy for the defense, because if the state can't convict her of the most serious type of neglect, then the murder charge doesn't apply. So if I'm the defense lawyer in this case, I'm trying to spread the blame around, trying to give some explanation of why she did what she did, and then focus on those lesser charges and suggest to the jury, there's a crime here, but it's not the most serious one. Find her guilty of this, but not the other.
Now, Paige, I know we have to sign up, so I'm going to ask you one more quick question. That means you don't expect to see in the defense's closing argument for them to say she's not guilty of anything.
I think you lose credibility with the jury at this point if you do that. I mean, everybody on the jury who's a parent is going to say, look, you should have done something for this kid. I don't know what the judge is going to tell me about the law, but you're responsible. This is your baby in your house, and you let him die. So I think if you try to suggest she didn't do anything wrong here, or she was really depressed, so give her a break, that's not going to fly. I think their best strategy is to try to get her convicted of a lesser included crime, which may save her from life in prison.
Yeah, and that's probably what's going to happen. That's probably what they'll argue. Paige Pate, thanks so much for coming on. Really appreciate your insight. And Abbas, stay with us. We're going to take a quick break, but when we come back, we'll hopefully be live in that Iowa courtroom. Stay tuned. Welcome back, everybody. We are ready to go live in the Cheyanne Harris case any moment. The judge is still providing those jury instructions, but as soon as those closing arguments start, we're going to jump live right back in there. But I want to turn back to Abbas. Abbas, you and I have been talking in the break about one of the things, the arguments that we were making before our last break about what the defense's strategy here in terms of postpartum depression and the idea of substance abuse and possibly putting the blame on the father, Zachary Cohen, who himself has been found guilty of murder and child endangerment. And as we know yesterday, his trial transcript from when he took the stand in his trial was read to the jury in this case. Your thoughts on that kind of defense?
Well, you know, I think that's a really, really interesting question. The previous guest, Page, laid out that he would try and point the finger to the husband, to the father, should I say, in order to try and get a lesser included crime. And in any normal case regarding a child like this and child endangerment, I would probably resist that defense because, you have a real good shot of losing the female jurors who may get inflamed with such a defense because,
and that's a good point. Now, Abbas, I'm sorry to cut you off, but we're getting word right now that the prosecution has just begun their closing argument. So let's jump back in there, and Abbas and I will be back to analyze it. So, Abbas, as we listen to the prosecution's closing argument, how is she doing at really laying out the elements of each crime? I'm curious your thoughts on it.
Well, that's interesting. I mean, closing argument is stylistic, and everybody has their, different, certain, stylistic ways of doing things. But she started off with what I anticipate she's going to finish with, which is that the defendant didn't accept the responsibility of blessing of having a child. And she talked about actions and consequences. And I think she wanted to set the scene with a big statement like that. However, she would then immediately went into the burden of proof, which is obviously very, very important. And I think she was very effective in trying to reduce what is a very, very high standard in a criminal case of beyond a reasonable doubt by talking about reasonableness and common sense, which kind of brings that standard. She was trying to bring that standard down and trying to explain to the jury that, hey, just use your common sense and, make reasonable inferences, which is really not the standard. And she did a phenomenal job with that. However, I would personally have gone through the timeline and really gone through the facts to really create a somber atmosphere personally. And it's my stylistic method of doing a closing argument.
Sure. But
she's very systematic in the way that she's doing it. And the fact is, when you have facts as strong as this particular prosecution does have, you don't necessarily have to go over the top. Now, when the facts are as somber and as sad and as heinous as they are in this case, I kind of like stillness. I personally, when in the well, do a closing argument, love to move around. But you have to choose, you have to think about the subject matter. And I think stillness would go a long way in this particular set of facts.
Yeah, because the facts can speak for themselves, particularly in this kind of case. We have to take a quick break. When we come back, we'll continue live in that Iowa courtroom. Stay tuned. Now, Abbas, she seems to be making a pretty strong argument that the neglect, how could it not be intentional? How could she not know what she was doing? So what's the defense going to do when they have to provide their closing argument?
It's, going back to what Paige said earlier, I was actually surprised the prosecutor didn't draw an objection because she stated that the defendant was the sole provider. And I'm not sure that that's the evidence that actually came into the trial. And it's bad form to object in a closing argument. But if you're misstating facts, that is grounds for an objection. So one of the things that we've talked about already on the show is trying to point the finger and at least share the blame to get a lower included crime rather than murder one.
Right. And Abbas, I'm sorry to cut you off. I want you to keep that thought because we have to take a quick break. But when we come back, let's analyze what the defense may do, because right now this is a very strong prosecution closing argument. We'll take a quick break. We'll be right back. Okay, let's talk about this right now with Abbas Kazerounian, trial attorney, talking about what we're seeing here. Now, she seems to be shaking her head at the prosecution during the closing argument, but she had an opportunity to testify. She chose not to. What do you think is going on right now?
Yeah, I mean, I think that was obviously strategic for her not to testify because she's a young lady here, and she would have probably not held up very well under cross-examination because obviously the obvious question is, what were you thinking? Why did you do this? And those are very difficult questions to answer, and it would be devastating to her case. I think the way to defend this case now, I mean, the prosecutor's now really getting into the nitty-gritty and doing a phenomenal job of going element by element. She's like, an assassin. And the facts are there for her. And I think we asked the question earlier, how are you going to defend this case? And what the defense has to do is deflect from the elements. They can't go and try and attack all the elements because the facts don't go for them. But the upside for them is that the prosecution have to prove every single element. And the one element that I think that they should attack from the defense's perspective is obviously intent, because they've used a diminished capacity defense.
Right.
And what I would do if I were a defense attorney in my closing argument is that you have to tell her story, which is the absolute antithesis of stylistically of attacking that closing argument, because the prosecution is going element by element and then filling in the facts of what's being proved. And then and as the prosecution then creates these great images of, like, the facts, or, of the heinous things that happened to this poor baby, it's patchy, because then she has to go to the legal element, the next legal element, and then start all over again. And I would deflect from that and concentrate on telling Ms. Harris's story from the defense's perspective.
And maybe that's what they'll do. I mean, we're waiting to see ultimately what they argue in their closing argument. Before we take our next break, though, I should let our viewers know we're keeping a careful eye, because there's some activity going on right now in the Jake Patterson courtroom, the man who has been charged with kidnapping 13-year-old Jamie Kloss and murdering her parents. We believe his preliminary hearing will start today. We'll be live in that courtroom. So let's take a quick break, and when we come back, who knows what to expect here on Law and Crime. We'll be right back. All right, the defense has begun their closing. Abbas, what do you make of it so far?
He came out swinging, that's for sure. I don't like his aggressive nature, but I mean, that's a stylistic issue. I think he's got to be a little bit, bring it down a notch, in my opinion. But I think what he's done to win credibility with the jury is that he gave them child endangerment. He said, yep, you proved it. And you go, and what he's doing very skillfully, I think, is trying to say, yes, we have a crime in Iowa for what my client did. It's called child endangerment, and they proved it. But it's not murder one. Murder one is the most violent of crimes in our state, and this is not what she did. And he tries to distinguish between, the willful deprivation of care, which is what child endangerment does, and the use of torture and the willful acts of what would create a murder one count. The problem for him here is that the prosecution really, really concentrated on this general intent and jury instruction that they got. And they hit it at least 6 or 7 times, and I anticipate in rebuttal that the prosecution is going to go back to the general intent issue. I don't like the fact that he's not using demonstrative when he is talking to the jury about the jury instructions and what they should be looking for. He's got his piece of paper, he can see it, but they can't. And I really, really want to see some facts and telling a story of what the defendant was going through to get that, low mental state.
And maybe we'll see it. We're going to take a break, but before we do, I also want to let you know, everybody, that we are also keeping a careful eye on the Jake Patterson courtroom in Wisconsin, the man who has been charged with kidnapping Jamie Kloss and murdering her parents. This is a preliminary hearing to determine if there's enough evidence to go forward ultimately with the trial. We will hopefully jump live there as well. We're going to take a quick break and be back in Iowa, so stay tuned here on Law and Crime. That's the defendant apparently having some questions with her attorney. Appears to be very upset based upon the prosecution's rebuttal closing argument. Abbas, the main question here is whether or not this is murder. The defense seems to concede this is child endangerment. What do you think of the back and forth on that question?
Well, I like what he did with it, as I mentioned in the last time we talked about it. But the problem is he didn't tell her story. He didn't, he went through the exercise of getting an expert and explaining that she had a diminished capacity, the fact that she was going through all these hard things in her life. Why not use it in your closing to explain and mitigate? And in fact, the prosecution was expecting them to talk about her age. And that's why in their actual closing argument, the prosecution was saying things like anybody would be able to would know that you have to feed a baby. Anybody. What really the prosecutor was saying is, don't be fooled by the fact that she looks young and she is young. But the defense didn't use that, didn't use the facts of their experts explaining why she had diminished capacity, and told her story through the evidence that came in through their experts. And I was very, very disappointed by that. What he did very well was say, hey, I'll give you that. You showed and proved child endangerment. It's not murder one. But the only reason it can't be murder one is because of the diminished capacity. In order to get the jury there, you have to tell the story, and you have to tell why she had the diminished capacity and what mitigating factors bring it to a diminished capacity. And unfortunately, I didn't see that.
And just to recap, again, the idea is not that she intended to kill Sterling, but that she intended or willfully or deliberately neglected him and refused to provide him that critical care. That becomes the key question here. We're going to take a quick break. When we come back, we'll be live in this courtroom.
I'm Amy Dash, anchor at the Law and Crime Network. People are always asking me, why did you leave your law job to be a legal reporter? And I say, stop, let's rewind and flip that script, because I went to law school to be a legal correspondent so that I could explain the law in a way that anyone can understand it. Can the imminent threat be something that has built over time, or does it have to be an imminent threat that exists at that very moment that he goes out and shoots to kill?
It's got to be imminent.
What I love about the Law and Crime Network is we're not just covering trials, we're examining justice so that the public can question it and help shape it. And through that coverage, I get to take the law and bring it down to earth for you. And that is truly an honor.
Hey everyone, I'm Jesse Weber, and this is more legal news you can use. Today's topic centers around an all too familiar one: drunk driving.
You're out, have a few drinks, get behind the wheel of your car, and then are pulled over by the police. So the question is, are you required to perform field sobriety tests? Let's break it down. There are a number of tests an officer can ask you to perform to determine how drunk you are, but the three big ones are the following. The HGN test. Officer observes how your eyes move as they follow a pen or flashlight. Walk and turn test. You would walk in a straight line, touching heel to toe, then turn around on one foot and walk back the same way. One leg stand test. You stand on one foot and count aloud. Now, by law, you don't actually have to perform field sobriety tests. That's right, you can refuse to take them. The same is true for a breathalyzer test, which measures blood alcohol concentration. However, even if you don't take the tests, officers can still arrest you if they have enough probable cause to believe your driving is impaired. Also, in many states, simply refusing to a breathalyzer test can result in a 6 to 12-month automatic suspension of your license, fines, and maybe even jail time if you have past DUI convictions. Bet many of you didn't know that. One more quick thing. Blood tests. Unless police have a warrant, you cannot be punished for refusing a blood test during a DUI arrest. But the most important thing, ladies and gentlemen, to avoid all of this, do not get behind the wheel of the car if you have been drinking. Go to lawandcrime.com for more legal news you can use.
I'm Rachel Stockman for Law and Crime, and here in Law and Crime, we love bringing you inside the courtroom action because it's so important for the public to see how our justice system works. Plus, you never know what's going to happen when the cameras are rolling.
Everybody, we're live right now in the Cheyanne Harris case out of Iowa. It's the prosecution's rebuttal closing argument. Let's go live.
This wasn't, I put my baby in the bathtub and I was so tired and I'd been so depressed and I walked out of the room and I forgot she was in there and she drowned. Okay, this wasn't, I had my kids in the car and my infant child was sleeping and my other two kids were screaming and we went to the grocery store and I forgot my baby in the car. And I've been depressed and I haven't been thinking right and I haven't been sleeping and it was an accident. That is not what we're talking about. This is, I put my baby in the back room and for 2 weeks I chose not to change him, feed him, hydrate him, love him, nothing. Knowing all the while that he's there. There's no mistake or accident here. That's the only thing that her mental health goes to. Was this a mistake or an accident? Did she generally not know what was going on? Her actions were continuous and consistent over a long period of time. So when you're looking at what's reasonable, you have to look at what's credible. Who do you find credible in this case? Now there's no dispute to Sterling's death. Okay, the crime scene testimony is unrefuted. Dr. Klein's testimony is unrefuted. Dr. Huntington's testimony is unrefuted. The only dispute is whether the defendant is responsible. Do you find her responsible for what happened to Sterling? She claims she's not, and she's provided you with reasons why. So do you find her credible? What you find reasonable is directly linked to who you find credible. The truth never changes. Her story's did. All right, she told Agent Calloway that she tried meth, but she was dishonest about that. Because you know that she used meth a lot, all the time. She told Agent Calloway never had meth in the house, not around the kids. But you know that's not true either, because Jordan Clark testified about going over there on at least 2 occasions and doing meth with the kids in the house. She told Agent Calloway the dog was at a friend's house. The dog didn't stay there. Her baby just died. She is being interviewed by a DCI agent. And she is more concerned about covering up her dog and her meth use than actually finding out what's wrong with her baby. Okay, what does that tell you? She knew what was wrong with her baby. She knew that she was responsible. She told Agent Calloway she fed Sterling 3 to 4 times a day, every day. Not true. She took Sterling out of the swing the night before and changed his diaper. Not true. She gave him a bottle the night before. Not true. She told Reed Palel he was crying the morning of the 30th. Absolutely not true. You know that from the evidence. She told Sheila Schrader she bathed Sterling every 3 days. Not true. Told Tina Shattuck he was fine when she fed him the night before at 9:30. Not true. She was not honest with any of those people. People who were there to help her find out what happened to her baby. Well, she didn't need that help because she knew what happened to her baby. And the only thing that she did was be dishonest with them so she could protect herself and to cover up what she did. So why would you believe that she's being honest about her mental health with the doctors? Over a year and a half while she's facing criminal charges. Right? Dr. O'Hara's opinion is largely based on the assumption that what defendant told him was true. She had everything to gain by what she said to him and nothing to lose. Do you find her credible? Do you find her statements to him so credible that it excuses this? That what happened to him is not malicious, that she didn't know what she was doing, which in turn made Sterling end up like this? Do you find that credible? And what about the mental health? The diagnoses do not matter. Now, it was said in the defense's closing that basically the doctors agreed. Well, the doctors didn't agree so much. Dr. Denner was pretty clear that if she had this global, systematic, severe depression, it would have looked different. But what Dr. Denner said, even if she had those things, she had depression, PTSD, addiction, there's nothing in the facts of this case that show that it affected her ability to care for a child, or that made her incapable of caring for her child. You have to look at the facts of the case. The diagnoses would have shown this global and persistent behavior that would have affected all aspects of her life, not just Sterling. That's why Nall is so important. There's a happy, healthy baby girl in that house, while her baby boy lay rotting in the back room. Depression doesn't work that way. You don't pick and choose like that. Dr. Denner said she was not so severely impaired that she could, without not knowing, allow her infant son to starve to death without being aware of it. Okay, so who do you find more credible? And more importantly, you didn't need a doctor to tell you that. That's just common sense. You saw it from the evidence. The state does not have to prove to you why she did this. We absolutely do not have to prove to you why. Did she commit a particular action? Did she know she was doing that? It wasn't a mistake or an accident? Was it malicious? Did Sterling end up dead? That's what we have to prove to you. We don't have to prove why. Right? Could it be because she didn't want him in the first place? Could be. Could it be her only care was pleasing Zach? Could be. Could it be that she wanted out of that apartment, she wanted back on the road with Zach and all, and Sterling was getting in the way of that? Could be. But the point is, it doesn't matter. All of those would be reasonable inferences, but the why doesn't matter. And does it change anything? You know, we have a lot of tragic things happen in our society. You can hear about people walking into elementaries and shooting children in movie theaters and killing people and all of that. But does it really matter when that person walked in there and did what they did and opened fire on young children? Do you really care why? It's interesting. We like to know it, but it doesn't change what happened. It doesn't change what it did. And in this case, the why doesn't change what she did. It doesn't matter. The other thing is, this didn't just happen out of the blue. It's not like there was some instantaneous break with reality in the month of August. You saw this early on. Remember something?
Okay, Abbas, I want to get some final questions from you, final answers from you, I should say.
Oh.
The idea here that meth and depression really shouldn't be a factor for the jury to consider. I mean, that's basically, if I'm hearing it correctly, for what the prosecution is saying. Is that accurate? Is that an accurate legal statement that this really doesn't excuse her behavior?
Well, I don't think it does, because if the defense has met their burden of showing their affirmative defense of diminished capacity through being under the influence of methamphetamines or through her depressive state, then I think that does negate her guilt of murder one. So I don't think that is necessarily a correct legal analysis on that. But one thing I want to draw attention to in the rebuttal is, for the viewers, the rebuttal is only meant to be limited to the topics covered by the closing of the defense. What the prosecution is doing very cleverly is trying to weave the facts to really intent, which was 99% of the closing of the defense, and actually going beyond the scope without drawing an objection on that, and really getting a second bite at the apple at doing a second closing with the facts that they want.
And they're the last thing the jury hears, the last thing. This is the prosecution's rebuttal. Abbas, I know we have to sign you off. Thank you so much for coming on. We really appreciate your perspective. We're going to take a quick break, and when we come back, we'll have more to talk about. Stay tuned.